Thank you for joining us today. My name is Glenn Lambie. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we've been around for 43 years. It'll be our 44th year next year. We have had those years of very continuous advocacy, education, and litigation on behalf of free enterprise principles, the rule of law, and limited government. These programs are one of the ways that we communicate our message. We also release papers and have a blog as well, and our litigation side remains our strongest asset and is very active in the Supreme Court and in state courts as well. It was the focus of a presidential debate question. The Biden-Harris environmental policy platform includes some very specific proposals to revitalize it at the federal level, and its proponents convinced two states, New Jersey and Connecticut, to pass targeted laws in 2020. Environmental justice appears primed for its moment. At a minimum, as the Fourth Circuit said this past January in an opinion, environmental justice won't merely be, quote, a box to be checked. For companies that have air and water emissions or hazardous waste as unavoidable byproducts of their manufacturing process, environmental justice can become a major factor in many of their business activities. That is especially true if the recent statement of one former EPA regional administrator and current environmental justice advocate comes to pass. Quote, every single thing that EPA and other federal agencies do must be viewed through the lens of environmental justice. Joining us today to give us the lay of the land and assess what to watch for in 2021 on environmental justice are two attorneys who appropriately practice the law firm that brands itself the Environmental Law Firm. Before introducing them, I just want to have a couple of housekeeping points. This program is being recorded. If you have any questions for our presenters, you're welcome to click on the Q&A link over at the right-hand side and type in the question. That will come to me. And also, if you wanted to download their slides, you can just click on the handouts tab over there as well. Joining us today is Julius Redd, who's a principal in the Washington, D.C. office of Beveridge and Diamond. He represents clients in complex matters in civil litigation and administrative regulatory proceedings under the Clean Water Act, the Safe Drinking Water Act, the Clean Air Act, RCRA, and CERCLA. Joining him is Hillary Jacobs, who is an associate in the DC office of Beveridge and Diamond. She maintains a general environmental and litigation and regulatory practice, working with clients nationwide across industrial sectors. Hillary holds an undergraduate degree in environmental studies and worked in the University of Maryland Environmental Law Clinic. Julius and Hillary have written a couple of excellent articles on environmental justice that are available at the Beveridge and Diamond website. Julius and Hillary, if you could get us started. Sorry, we seem to be having some technical difficulties with Julius. His microphone is on.
All right, well, sorry for that technical difficulty. This is Hillary Jacobs. I'm going to take over for my colleague Julius, who is having some mic issues, and he'll let me know when he can jump back in. But this is just, thank you so much to Glenn and the Washington Legal Foundation for having Julius and myself. We're so happy to be here and be speaking to everyone. So this is just the general agenda of what we're going to cover today. First of all, I'm not going to read off the slide, but we're basically going to cover what is the business case for considering environmental justice, period. We're going to provide you with some important background on environmental justice in the US, and then cover what is expected to come, as Glenn helpfully highlighted. And then at the last part of our presentation, we'll talk about some best practices that you can take back to your company. Looks like okay, I think the slides are up. They disappeared for me for a moment. Please excuse that. So moving on. So first of all, why should you consider environmental justice? Well, I'm so glad that you asked. There's a lot happening right now, as Glenn previewed, and one of the biggest reasons to get involved in this and consider it in your business practices is to get ahead of evolving state environmental justice regulatory landscape and anticipated federal environmental justice activity in the new administration. So as some of you may know, the President-elect Biden's administration transition team includes environmental attorneys with really strong environmental justice background, including Patrice Sims from Earth Justice for EPA and Celia Martinez from the Center for Earth, Energy, and Democracy for the Center for Environmental Quality. Other reasons for your business: avoid project development opposition and costly time-consuming delays, avoid reputational harm, and enhance your corporate brand. So there are a lot of reasons to touch on this with your business, and I'm going to turn it over to Julius, who I think is here. Julius, are you available to speak for the next slide?
I am on the phone. Can you guys hear me?
Yes, we sure can. Man,
Excellent.
technology.
Yeah, I'm sorry about that. I don't know exactly what happened. 5 minutes before the presentation started, Glenn, Hillary, and I were all on, and it was working fine. But in any event, Hillary did a great job in covering the first slide. Right. So, and thank you very much, Hillary, for sort of offering some thoughts on the business case for environmental justice. There's one thing that I did want to flag for our audience in case they're interested. We will be issuing a podcast, publishing a podcast in the coming days, in which I have a great discussion with Carlos Brown, who is the general counsel of Dominion Energy. And he offers some thoughts with respect to why, in his view, it is important for businesses to consider environmental justice. And I really commend that to all of you as to further rationale as to why you should all consider environmental justice in your business operations. All right, so kind of turning back to the slide on the screen. So what is environmental justice? What are we saying that you all should consider considering in your business operations? Well, you all can read, so I won't read the slide to you, but the first definition that we have listed comes from the US EPA, and that's generally widely accepted definition of environmental justice. It's a very substantially similar definition across the federal agencies, and many states also have a similar definition of environmental justice. We have listed there the definition of environmental justice from the state of California. And as you'll see that they are substantially similar, and some of the key tenets or principles that we see that's often cited in the definition of environmental justice is really the ideas of fair treatment and meaningful involvement. And the concept of fair treatment is generally sort of interpreted as no group of people should bear a disproportionate share of the negative environmental consequences resulting from industrial activities or operations in their local community. And meaningful involvement was really interpreted to mean as communities having the opportunity to say what happens in their communities from an environmental and public health perspective. Now, that doesn't mean that they control your project or they have some veto power over your project, but it really gets to the idea that they should have the ability to have some input and their feedback being considered with project planning or project expansion activities. There's one thing that I wanted to know, and I know this webinar is really focused on domestic policy, but my sense is a lot of the audience members may have operations that are international. And so we have listed here how the concept of environmental justice is framed in the international context. This text is taken from a 2014 United Nations Development Program report, and it really speaks to environmental justice in terms of defense and protection of one's right to a clean environment and inequitable access to benefits from natural resources. A related concept that I wanted to flag for this audience is the ongoing movement right now to draft a legal definition of the term ecocide, which are really aimed at so-called crimes against the environment. In recent weeks, a panel of legal experts from around the world, and the panel is sort of made up of individuals like former judges of the International Criminal Court. They have been convening and they have been working on developing a legally enforceable definition of ecocide with the goal of publishing that definition early next year. French Prime Minister Emmanuel Macron is one of the champions of the idea, and the Belgium government is also supportive of the idea as well. I mean, that's really all I think for purposes of this presentation is all I really wanted to say about that, but I just wanted to flag that as an upcoming development on the horizon for your consideration. The next slide sort of looks at the EJ's origins and key milestones, sort of how do we get to where we are today. I'm not going to spend a lot of time on this slide, but I just wanted to flag for this audience that EJ really has its origins and its roots in the civil rights movement. Probably a generation or two ago, there really wasn't a concept of environmental justice. It was just called plain old civil rights. When I sort of give the history of environmental justice, I like to start with the 1968 Memphis sanitation workers strike. So astute observers of American history might note that in 1968, Dr. Martin Luther King was assassinated in Memphis, Tennessee. And why was he in Memphis, Tennessee? It was to support the sanitation workers strike. One of the next seminal events in the EJ movement is the 1982 sit-in to protest the PCB landfill in Warren County, North Carolina, that was going to be located in a predominantly Black community. Many commenters cite this event as sort of the genesis or the beginning of the EJ movement. The next sort of noteworthy milestone in the EJ movement is the 1987 Toxic Waste and Waste Report. So that report, along with the report that came out a couple of years earlier from the Government Accountability Office, are some of the first pieces of empirical evidence that linked the siting of certain industrial facilities in low-income and minority neighborhoods. One of the really the next key milestone in the EJ movement occurred in 1994 when Bill Clinton signed Executive Order 12898. We're going to talk probably a lot about this today, so I'm not going to discuss it a lot here, but broadly, it requires EJ to be considered throughout the federal agencies as they fulfill their mission, and requires interagency collaboration. As we get into the 2000s, we see many states taking their lead from the federal government, and states also beginning to establish their own environmental justice policies. And then in recent years, we have seen a significant increase in environmental justice litigation and environmental justice legislative proposals at the federal level. And as Glenn flagged in his opening remarks, those of us who watched the second presidential debate saw, I think, climate change issues in general get two questions, but specifically there was a question about environmental justice during the presidential debate. Really, a key takeaway here is for some of the text that we have there on the slide. For the EJ movement has origins in the civil rights movement, and sort of given the recent social justice movement, sort of amplified by the ramifications of the COVID-19 pandemic and the election that we just went through, environmental justice has really gained significant prominence as of late. And then I will turn over to my colleague, Hillary, to lead us through the current landscape with regards to federal EJ law.
Thank you, Julius. So as Julius previewed, we're going to take just a second to give you a current overview of what's going on in the federal landscape. So there is no dedicated federal environmental justice law that imposes compliance requirements on the regulated community. That being said, there obviously are existing authorities that touch on or can be used to advance environmental justice. As Julius mentioned, the 1994 executive order is one of the main authorities that exists right now and is still in effect. In addition to that, there are a couple of tools that are not directly designed to address environmental justice, but are used as tools by EJ advocates. One of the major ones is the National Environmental Policy Act, which requires the federal government to consider environmental impacts before taking major federal actions, which can include issuing permits that may significantly affect human health and the environment. Section 101 of NEPA speaks broadly to the consideration of social and economic factors. This has been interpreted to require a hard look at EJ issues, but typically does not preclude federal action. So it's not like this would stop a permit from being issued. Additionally, in the absence of federal law, a broad sweeping federal law addressing environmental justice activists have been really creative in using existing laws to raise EJ concerns, including the Civil Rights Act. So Title VI of the Civil Rights Act of 1964 prohibits federal funding recipients from discriminating on the basis of race, and Title VIII of the Civil Rights Act of 1968 prohibits discrimination in the sale, rental, financing, and other housing-related transactions on the basis of race, color, religion, sex, familial status, national origin, and disability. So while neither of these authorities directly address environmental justice, they often are used as a mechanism for advancing environmental justice concerns. And we'll touch on Title VIII and how that's been used recently a little later on. So to give you an overview, a very high-level overview of where state environmental justice law and policy is right now, we wanted to just note that the states because all states receive federal funding. All states at a minimum have some Title VI compliance related language or policy. And to just go back to that for a second, Title VI of the Civil Rights Act prohibits recipients of federal funds from discriminating on the basis of race, color, national origin in their programs or activities. So to that extent, all states address environmental justice in that it's tied to funding. The vast majority of states do address environmental justice in some fashion, whether via legislation, agency policy or guidance, or advisory groups. But the states we've highlighted in green have very developed, advanced environmental justice regimes. For instance, California is regarded as an environmental justice pioneer and has robust EJ activity, including a subdivision in the Attorney General's office, which is dedicated to environmental justice enforcement, and publicly available tools for GIS mapping that is useful for identifying potential EJ communities. We also listed on the right of the slide some states to watch based on their recent robust developments and activity, and we're going to talk about some of them right now. So as Glenn said at the outset, one of the big states, two of the big states that have been really active lately include New Jersey and Connecticut. In September, the governor of New Jersey signed landmark environmental justice legislation into law that requires the applicants seeking new or renewed permits for specific categories of facilities cited in overburdened communities, which is defined by the law, to submit an environmental justice impact statement that evaluates the potential cumulative environmental and public health stressors associated with the permitted activity. This legislation basically gives the New Jersey Department of Environmental Protection authority to impose conditions on or deny a permit in its entirety based on their review of the permit applicant's environmental justice impact statement, which is very big, and this is the first law we've seen of its kind. We've also heard that this could be used as a model for future legislation, which wouldn't necessarily happen anytime soon, but is something to keep in mind. As Glenn also previewed, Connecticut passed a bill very recently in October, amending the state's existing environmental justice legislation to increase opportunities for community stakeholders to make an agreement with new developers in the area to lessen environmental impacts of new developments. It requires developers with a project in a town with more than 5 affecting facilities, which can mean any electric generating facility with a certain capacity, certain types of solid waste incinerators and recycling facilities, landfills, et cetera, to make an agreement with the owner and developer of other sites, and the new owner has to agree to lessen the environmental impact of their development. The Pennsylvania Department of Environmental Protection has also been updating and revising its 2004 environmental justice public participation policy, and they started that process in 2017. But in October of this year, they issued a notice stating that they would withdraw the draft policy and keep working on it to, quote, develop a policy that will focus on integrating environmental justice into other department practices and policies to provide tangible benefits to communities. So a lot of regulators across the states are talking about this and thinking hard about this. As the slide mentioned, a couple of states recently have established environmental justice advocacy groups, and those groups are quite active. For instance, North Carolina just released the other day their first biannual report outlining policy recommendations to address disparities in communities of color disproportionately impacted by COVID. Also of note, Texas has legislation pending right now that would establish the Texas Environmental Advisory Council. So we'll have to keep our eyes peeled for what happens there. And I'll turn it back to Julius for the next slide.
Thank you much, Hillary. And as you can all appreciate from what Hillary just walked us through, there's a lot of activity happening at the state level right now. And not to be outdone, in recent years, there has been a lot of EJ activity on the federal level as well. On the slide, we have a selection of some of the recently proposed EJ-specific legislation. These are not an exhaustive list of all the federal legislation that has been proposed. There are some other EJ-related bills or larger, or I guess more encompassing bills that have specific aspects, EJ aspects to them. But these are some of the more interesting ones, I think. And one of the key takeaways here on this slide to note is many of the EJ-related legislative proposals, particularly with respect to the Environmental Justice Act of 2019, which was introduced by Senator Cory Booker, have made their way into President-elect Biden's campaign platform. So I do want to note here that I think, given how the election went in November, I think it's probably unlikely that we will see very sweeping, broad, EJ-specific legislation similar to what we saw come out of New Jersey. Sort of irrespective, the balance of power in the Senate is still uncertain, pending the results of the runoff election in a couple of weeks in Georgia. But even notwithstanding that, the Democratic Party is sort of has a broad spectrum of ideology, and we have already seen some Congress members come out and issue admonitions to the Democratic Party about engaging in or introducing legislation or attempting to adopt pass legislation that is extremely progressive. So I think that will have some moderating effect on the legislative proposals that we eventually see come out of Congress. I mean, had there been this blue wave that many commentators predicted, the landscape might look a little different. But as it stands now, I think much of the EJ activity that we anticipate coming out of the Biden administration will likely be done through executive action. And with that, I think I'm going to turn back over to Hillary to start leading us through some of the anticipated executive action that we see coming out of the Biden administration.
Thank you, Julius. And I turned off my camera due to some errors with the network. I want to make sure folks can at least hear me. So as Julius previewed, there's a lot we're expecting from this incoming administration. And I won't repeat what he said, but what's generally true under any administration is that political appointees at the helm of agencies have a lot of discretion to interpret environmental laws in line with their political philosophy of that administration. And that will certainly be true with this upcoming administration. What this can mean is a lot of new agency interpretations, regulatory actions, and guidance, and certainly some expanded environmental justice community engagement and federal actions like permitting. So that's just some general actions we can expect. And I'll hand it back over to Julius to talk about the next element of Biden's plan.
Sure, thank you much, Hillary. So one of the key campaign promises that I think the Biden administration will likely seek to fulfill, and probably fulfill quickly, is his pledge to revise and invigorate Executive Order 12898. And we anticipate, I should say, that happening through several different avenues. One, I think that the administration is likely to rely heavily on the White House's White House Council on Environmental Quality. For one, we know that the lead transition or the lead person of the transition team is Cecilia Martinez, who Hillary noted earlier has a strong background in environmental justice. And some of the names that we have seen reported in the press as potentially head of CEQ, folks like Mustafa Santiago Arli, are folks that have strong EJ background. He used to work in the EPA's Environmental Justice Office. I believe now he is with the World Wildlife Federation, I believe, and he is a very strong advocate for EJ. So some of the sort of further evidence that the Biden administration intends to really rely on CEQ as a mechanism of fulfilling its EJ priority. Some other tangible action items what we're likely to see is the White House reestablish the Environmental Justice Interagency Council and also establish the White House Environmental Justice Advisory Council, both of which will report directly to the CEQ. We anticipate those entities to issue performance metrics for executive agencies to measure how they are implementing environmental justice as they perform their work and fulfill their mission. Well, those are some of the highlights that we expect to see out of President Biden in his pledge to revise and reinvigorate Executive Order 12898 and enhance agency accountability. I'm going to turn back over to Hillary to lead us through the next slide.
Thanks, Julius. So under President-elect's campaign plan for environmental justice, there are a couple of other major things we can expect. One of the biggest is a huge effort to advance environmental justice through dedicated enforcement efforts, including through the use of Title VI. So a couple of things that have been promised include establishing an environmental and climate justice division of the Department of Justice. And we'd like to note that depending on how the new administration goes about establishing this branch, congressional approval may be required, although we've put this in the section that technically does not require congressional approval. But there are things that can be done without needing new appropriations. And one of those could be creating sections in existing divisions of the Department of Justice, the Environmental and Natural Resource Damages section for environmental justice and climate matters. And that would not require additional congressional action. The president-elect has also indicated that he will instruct the Attorney General and this new office of the Department of Justice to implement Senator Cory Booker's Environmental Justice Act of 2019 that Julius mentioned earlier to the extent possible through executive action. So that's a pretty sweeping law, and a lot of the things that were promised in that cannot be achieved without congressional involvement. But a couple of things to note that could be achieved without congressional involvement would be improving public participation policies, establishing requirements for federal agencies to address environmental justice, et cetera. Additionally, this new administration is expected to overhaul EPA's program responsible for enforcing Title VI of the Civil Rights Act, which is called the External Civil Rights Compliance Office, or ERCO, which has long been criticized for not acting on the majority of Title VI complaints filed. One of the major things that Biden has advanced in his platform is rescinding two previous decisions that Select Steel and Angelita C. And if this would happen, it would result in expanded Title VI remedies for environmental justice violations. So just to talk about those two cases for just a moment to shed some light on what rescinding them would mean. Angelita C. Versus the California Department of Pesticide Regulations was a case that occurred in the late 1990s. A complaint by local environmental groups and citizens alleged that the California Department of Pesticide Regulations discriminated on the basis of race by permitting the greater use of methyl bromide and other fumigants near schools with Latino school children than they did at schools with fewer Latino school children. So this kind of sat around for nearly 12 years, and the Office of Civil Rights finally made a preliminary finding of a Title VI violation in 2011, but they did not contact the complainants before settling. The settlement was really criticized for being deficient. It required the department to install one new air monitor, maintain some existing monitors, and conduct outreach to the surrounding Latino community. And EPA eventually denied the complainants' request to reopen the settlement agreement and just didn't respond to their complaints about not being involved in this settlement process. There was subsequent litigation that affirmed their decision, EPA's decision to settle and the scope of its investigation, but rescinding this would basically end up with some kind of additional requirements for public involvement and complainants' involvement in the settlement of Title VI claims. Select Steel was also a Title VI complaint against the Michigan Department of Environmental Quality, and that complaint alleged discrimination in how Clean Air Act permits were issued. This specifically related to the agency's decision to permit a steel recycling facility in a predominantly African-American neighborhood in Flint, Michigan. EPA dismissed the case because the permittee had complied with Clean Air Act standards, and so they found that there was no violation of civil rights. And so rescinding this would end up with basically looking at environmental laws separate from environmental justice in when it comes to environmental justice concerns and allegations. So just because you complied with a federal statute would not grant you immunity from environmental justice complaints under Title VI. One other action expected in the enforcement realm is the Biden administration is expected to conduct a rulemaking and open a public comment process to seek Americans' input on agency guidance for investigating Title VI administrative complaints. EPA has issued draft guidance. They did that back in 2000 and invited public comment, but has been largely non-responsive in responding to those comments. So this would reopen that process. And I'll flip it back to Julius for the next slide.
Great, thank you much, Hillary. So this slide again gets to one of the points that Glenn made at the top of the program. During the presidential debate, President-elect Biden specifically mentioned fence line communities, and so he sort of told a personal story about how environmental justice issues are personal to him and sort of his experience. We really anticipate the Biden administration giving communities tools to be better advocates for themselves. Some of that would be through increased monitoring and data collection. The graphic we have on the screen relates to EJ Screen, which is a GIS mapping tool that EPA prepared that allows communities to find out more about the certain facilities that are in their local communities. Part of President-elect Biden's campaign platform was to evolve the EJ Screen to what I like to call EJ Screen 2.0 to have a greater focus on climate and economic justice. So I think that will be a huge part of what the Biden administration is able to do by itself without any need for congressional action. There's one of the points in the box on the left side of the screen, the rollbacks that we don't have a particular slide for because there is not a lot of content, I don't think, specifically directed at environmental justice. But we will be remiss if we didn't mention that under the Trump administration, there has been a lot of rollbacks of environmental regulations. I believe they had a policy for every one environmental regulation that was instituted. You had to roll back 2 of them. We anticipate seeing a lot of those rollbacks get rolled back by the Biden administration. And while many don't focus specifically on environmental justice, there are implications for environmental justice. One that I think it's noteworthy to flag is both the DOJ's policy on using SEPs in settlement of enforcement cases. SEPs are supplemental environmental projects, and that's one item that I think it's useful for many purposes. It helps communities by introducing new features into their community that wouldn't have otherwise been there necessarily. And I think a lot of our clients that we have worked with embrace SEPs and like to use them as well, because it helps to facilitate the settlement of compliance investigations and actions, and it also helps the company give back to the local community. So with that, I will turn it back over to Hillary to talk about the last points in this section.
Thanks again, Julius. So on this slide, we just wanted to touch on a couple of things that have either been promised or would relate to any advancement of environmental justice policy and law under the new administration that would, in fact, require congressional action, and as Julius mentioned earlier in the presentation, therefore are a little bit less likely than a lot of the other things, depending on how this Georgia Senate runoff goes shortly. So one of the biggest things that the Biden campaign promised was enacting some legislation that would reinstitute a private right of action not to sue under Title VI. Which would effectively overturn a 2001 Supreme Court decision in the case Alexander versus Sandoval, in which the court held that there were some agency regulations prohibiting disparate impact, and the court held that those regulations did not create a private right of action. And so what this legislation would do would provide another avenue and a really significant avenue for Title VI environmental justice lawsuits. We wouldn't see any legislation like this. I mean, we could, but it's a little bit less likely depending on the composition of Congress. The plan also talked about, and by the plan, I mean Biden's environmental justice plan, discussed implementing Senator Cory Booker's Environmental Justice Act of 2019 to the extent possible, which we touched on earlier. And there are a couple of things in that would obviously require congressional action. So that would include codifying and expanding executive orders, grant programs, et cetera. So those things are a little bit less likely with the Congress we're facing. Additionally, appropriations for agencies to prioritize environmental justice or otherwise dedicate resources to it won't necessarily be held up, but just will require congressional authorization. And so it's just something to keep in mind when you're watching this space. And we're going to take another couple minutes to talk about a couple of cases and recent environmental justice litigation and advocacy. And I'll turn it over to Julius to talk about this recent case, Friends of Buckingham.
So thanks much, Hillary. We're going to try to be mindful of time. We'll try to move through this section pretty quickly. but I do think this section is important because it sort of shows recent examples of where the rubber hits the road and sort of why, from a business perspective, it is important, we think, to consider environmental justice to mitigate some of the risks that that come with not considering environmental justice issues. And it's also important, I think, for us to know that we are not, either us personally nor a firm, are involved in any of the examples that we discuss. We're just informed by just reading the general press and the various court opinions and things of that nature. So the first case I want to discuss is the Friends of Buckingham case. This case relates to the development of the Atlantic Coast Pipeline. The developers of that pipeline sought to seek approval of a compressor station in Buckingham, in the community of Union Hill in Buckingham County, which is a historically Black community. Under Virginia state law, the State Air Pollution Control Board had to consider the potential for disproportionate health impacts from the compressor station. The Fourth Circuit ultimately agreed with the petitioners here that the State Pollution Control Board failed in their duty to consider the disproportionate health impacts on a local community from the compressor station. There's a couple of things here that I think are really important about this case. One is that the proposed compressor station would have been in compliance with general environmental law. It would have been in compliance with the limits set under the Clean Air Act. Notwithstanding that, the Fourth Circuit nonetheless found that the State Air Pollution Control Board's analysis was inadequate to account for environmental justice concerns. And I think Glenn also noted this quote earlier in his opening segment, and I think that he's absolutely right. For flagging that quote, the Fourth Circuit, in that opinion, explained that environmental justice is not merely a box to be checked, and the board's failure to consider the disproportionate impact on those closest to the compressor station resulted in a flawed analysis. I think that is the direction that we are likely to see sort of many courts go with respect to environmental justice issues, simply showing that your proposed project complies with the environmental sort of pollutant standards is not necessarily going to be sufficient to account for environmental justice concerns. And that is sort of a shift away from the Select Steel decision that Hillary mentioned earlier, in which EPA found that complying with the Clean Air Act emission limits were sufficient, and it didn't need to do any further environmental justice analysis. I want to really quickly talk about the Formosa case out of Louisiana. Really quickly, it deals with Formosa's attempts to permit a petrochemical facility in so-called Cancer Alley, which is the area between New Orleans and Baton Rouge, where there are numerous different industries present in that locale. Sort of, so that permit has been challenged on, or the permits issued to Formosa have been challenged on several different grounds in both federal and state court. And as recently as last month, a state court judge in Louisiana remanded the Louisiana Department of Environmental Quality's grant of the permit back to the environmental agency in Louisiana and require them to conduct an analysis that considers environmental justice. And the judge in her oral opinion really made some very pointed comments about the existence of environmental racism and the state government's failure to account for that. That's all the comments that I wanted to make about that. I'm going to turn it over to Hillary to really quickly discuss the housing discrimination case out of Chicago, because I think it really illustrates the points of how environmental justice advocates are creative in their use of federal civil rights laws in raising EJ concerns.
Yeah, thanks, Julius. You hit the points that I mainly wanted to hit with this particular slide. I'll just give some brief background on the case. Very recently, a coalition of environmental groups filed a complaint with the U.S. Department of Housing and Urban Development in August, alleging that the city of Chicago violated Title VIII of the Civil Rights Act of 1968, which we mentioned earlier, and the Housing and Community Development Act of 1974, based on the city's decision to relocate a $6 billion recycling facility from a wealthy community to environmental justice community. So as Julius mentioned, in one of the themes throughout this presentation is that environmental justice advocates really will get creative, and this is a very good example. The Department of Housing and Urban Development recently confirmed that the department has opened a complaint to look into the allegations. The facility is waiting on one last permit from the city before the new operation can be started, and HUD recently asked the city to hold off on issuing that last permit while it conducts its investigation, which is very interesting, and it'll be fascinating to see where that goes. And I'll turn it back to Julius for the remainder of the presentation.
Thank you much, Hillary. So there's, whoops, I think I skipped this slide here. There is one, I want to mention this case really quickly because it deals with an enforcement action out of the state of New Jersey for several reasons. One, the New Jersey, as I think we discussed earlier, the New Jersey State AG's office has created a special subdivision of the AG office that is focused on environmental justice enforcement. And this Pennant Corporation case is one example of that. It deals with an industrial facility in Newark, New Jersey that has discharged certain pollutants to both groundwater and to the neighboring communities. And the key, one of the key themes or issues I want to flag from this is that the state AG's office and the state DEP issued a press release, and you can see a screenshot of it there on the left, in which they specifically noted their enforcement of environmental compliance issues in environmental justice communities. I mean, if you really read through the various non-compliance incidents that they note in this press release, I think in past times, they may have just been framed as just regular enforcement actions. But in the context of the current climate that we're in, I think enforcement agencies are looking for opportunities to really tout their proactive enforcement of environmental laws in EJ community, in so-called environmental justice communities. And I think this is one example of that. So from sort of enforcement perspective, I think we might see similar strategies from a Biden Attorney General's office in which they are specifically looking for opportunities to enforce environmental laws in environmental justice communities. And I will not be surprised if, similar to New Jersey, if they are very public about those enforcement efforts and really showcase what they're doing in that space. I want to get through some of the best practices that have been informed by our representation of clients in various industries everywhere from the oil and gas sector to utility sector to the tech sector to the waste management sector, in addition to some of what we learned from some of the recent activity that we just walked you through. So one of the key themes that is not on the slide, but I think we tried to really highlight here is really know the law. With respect to environmental justice, the landscape is evolving almost daily. It's hard to keep up. Things really move at a breakneck pace. So I think it's really incumbent upon the regulated community to really know and understand how the law and policy changes and shifts may affect their operations. Additionally, we really recommend that companies develop an environmental justice policy. Consider having one both internally and an external public-facing environmental justice policy. Similar to that, companies should really develop an implementation plan or environmental justice implementation framework, so they are really not just paying lip service to it, but are incorporating environmental justice considerations into their operations. What I think is also very important for the regulated community is to have a documentation of that process. It really protects the company if there is opposition or if they are facing some sort of enforcement action, where they can really document that they are in fact considering environmental justice principles. Additionally, I mentioned EJ Screen earlier. California has Cal EnviroScreen, which is sort of a precursor to EJ Screen, but use available data sets and tools to identify potential environmental justice communities. But that should only be a first step, and that should not be all that you do. We really recommend ground truthing. That sort of fancy way of saying, confirm that the information that you are learning from the data tools are aligned with the facts and what you actually see on the ground. This should be both a qualitative analysis of the community to ensure that the data sets that you're seeing from these data tools is an accurate representation of what you see on the ground. And probably one of the largest or key takeaways is to engage with the communities in which you have operations. No one can tell you about the community other than the community itself. You should really strive to build trust with the community, particularly when you're not in a oppositional state or when you're not sort of seeking to have a permit or open a new facility, to really start that process of building trust. So when it comes time and you do need to expand a facility or seek a permit, you have some equity in the relationship with the community, and they can look at you as a trustworthy partner. I think the last slide here are some of the key takeaways from today's presentation. I will get to the bottom line right away, but hopefully we're able to demonstrate today that there is a strong business case for proactive consideration of environmental justice issues to mitigate risk, avoid disruptions to operations, and save save time and money, and protect your corporate brand and image. We only have a minute or so left, and I saw a couple of questions pop up as we were going through. I tried to answer them as we went along. I think my screen might be frozen. I'm trying to get back to the question tab and try to answer them. So go ahead, Glenn.
Would you like me to go ahead and ask them?
Sure, go for it.
Okay, so one of the questions was, is EJ oversight and enforcement reactive or proactive? Do communities need to report in order for agencies to act on environmental justice issues?
Yeah, thanks, Glenn. And this is one of the ones that I tried to answer during the presentation, specifically with respect to the Pennant Corporation example in New Jersey. I think under the Biden administration, I'm going to take to the federal government for a second. I think under the Biden administration, EJ enforcement is going to be proactive. I anticipate the Biden administration looking for opportunities to enforce environmental laws in EJ communities, sort of particularly look for communities that may have not been prioritized before and specifically enforce environmental laws in those communities. But I think there's also a reactive aspect to it where the EJ communities in general will have more access to monitoring and data, and they can sort of self-select and raise their hand if they have concerns in their local community, and they can specifically call out issues to enforcement officials for consideration.
One of the other questions had I think you addressed some of the question, but in terms of what companies can do, should they be looking at incorporating EJ into environmental risk assessment in the supply chain, auditing programs, those sorts of things?
Yes, and so I think that's a great question, Glenn, and for whoever asked it. And I tried. That's one reason why I try to speed through the recent activities to get to best practices. Yes, I think companies should certainly be doing a self-assessment of their operations and ensuring that they have policies in place that consider environmental justice, and importantly, they have documented processes to show that. So if there is an issue, they can point to their processes and they can show how they have been implemented to consider environmental justice. Sort of in a larger context, one of the issues that I got to earlier in a larger context of mandatory reporting in ESG, that we are seeing coming online. Companies are being asked to report on their human rights record. So I think that's another reason in the whole concept of climate justice. I think that's another reason why companies should be proactive in this space and really take a hard look at their operations and their processes and ensure that they have a documented method of showing that they are truly considering environmental justice principles.
So you had talked about the concept of environmental justice communities. What are there definitions of that in any of the laws that have been passed or the guidelines that have been issued by the federal regulators?
Yes, on the federal level, there are any number of guidance documents in which EPA sort of starts with their baseline definition of environmental justice and sort of expands upon that and talks about environmental justice communities. They are usually around low income communities. There's usually a threshold within the federal poverty line. Some jurisdictions do it differently, but usually it's somewhere around 35 to 40% of being within the federal poverty line. Racial and ethnic minorities, a presence of those in the community, usually over 50% as a threshold where it's considered to be an environmental justice community. In New Jersey, they use the term of art overburdened communities, And in their recent legislation, they go a step further and they discuss so-called linguistically isolated communities. And so those are communities where English is not the predominant language spoken. It could be Spanish, it could be some dialect of Chinese, it could be any number of sort of languages that are predominantly spoken in that community. In New Jersey anyway, they define so-called overburdened communities as that being linguistically isolated can be one metric of being an overburdened community.
So one of the problems that the environmental justice community has always pointed to in government is that the EPA Office of Civil Rights has been very slow in reacting to complaints that have been lodged with them that relate to usually state permitting activities. Is that going to be a part of what you see as a new focus for the incoming administration?
Yes, I think you are exactly right, and I believe Hillary talked about this some during the presentation that the EPA office or External Office of Civil Rights has received a lot of criticism in being slow in responding to particularly Title VI complaints, and I anticipate that through EO 12898, that's going to be a focus of the incoming Biden administration, where they prioritize ensuring that complaints from communities get investigated and addressed in a timely manner. One of the mechanisms that we discussed earlier, that through the White House Council on Environmental Quality, they're going to be issuing reporting requirements and performance metrics for various federal agencies, and I might anticipate that sort of the time it takes to respond to complaints from environmental justice communities might be one of the metrics upon which agencies are judged upon.
There have been some suits filed, as from what I recall. I think most recently there was a decision in it was a district court in Oakland that said that the EPA had violated its statute basically and going so slow. Do you expect those kinds of challenges to be lodged, and is there a likelihood that EPA will sort of sue and settle? They'll accept the suit and then settle it as a way of trying to advance EJ forward?
Yeah, that's well. First, you are right for flagging the recent matter, Title VI matter related to Oakland. As far as strategies wise, so from the Angelita C decision that that Hillary discussed, one of the criticisms of that decision of EPA was that they preliminarily found sort of discrimination under Title VI, but they went ahead and settled the action without consulting with the community and without sort of seeking their input. Sort of, if you think about the definition of environmental justice, which talks about the meaningful involvement of communities, it's sort of ironic that it sort of proceeded on that path. I would anticipate that if EPA or any federal agency intends to settle one of these Title VI complaints, there will be a greater opportunity for communities to provide their input and sort of give some feedback to the agency with respect to the potential settlement.
And if I could just jump in for one moment, one point I want to reiterate is that part of the president-elect's platform on environmental justice is to conduct a rulemaking and comment period on agency guidance for investigating these complaints. So I suspect that settlement and other aspects of how the agency does this will be addressed in that process.
Well, thanks. Any finishing thoughts before we end the program?
Well, only thing to thank you, Glenn, and the Washington Legal Foundation for giving us this opportunity. We very much appreciate it. As Glenn noted at the top of this webinar, feel free to check out our website, bdlaw.com. There are several articles that Hillary and I and some of our colleagues have authored related to recent developments in environmental justice. And as we are the environmental law firm, there are lots of resources related to environmental law in general, both anticipating what we might expect to see out of the Biden administration broadly with respect to all areas of environmental law, not just related to environmental justice.
Thanks very much, Julius and Hillary, and thanks everybody for joining us.
Thank you all.